Hello, this is Dane Cialino, and welcome to our introduction to CaseMap. We've talked before about how important it is as a lawyer to organize your cases, and by organize your cases, I mean organize all aspects of your cases, not just the facts of your cases and the documents, but also the events that have happened in your cases, the issues that relate to your cases, and the to-dos. We have talked in the past about managing calendars, managing productivity and to-do lists for your practice. What we're now going to talk about are managing the events that happened in the past in your cases, and also the keeping track of what needs to be done on a particular case as opposed to what needs to be done generally in your practice. CaseMap starts with this basic premise that cases are comprised of people, of events, of issues. And given that that's what makes a case, CaseMap is designed to allow you to organize these aspects. Now, what we're talking about in this lecture is case-level organization. We're not talking about file-level organization, like, for example, how you should name your files, or folder-level organization, where you should keep those files on your computer. What we're now talking about is case-level organization. Cases, of course, are bigger than just files. Cases involve, as we've already said, issues, people, sometimes places, events, and it's this level of organization that our focus now turns to, and more particularly to CaseMap. CaseMap is a software program that used to be written and sold by a company called CaseSoft. I would imagine this program has been actively being used by lawyers probably since the late 90s. I know the first case that I ever used CaseMap on was a federal murder case, and I used it probably in the 1998-1999 timeframe. But in the years since, CaseMap has been bought by LexisNexis, and of course we all know LexisNexis is one of the two big players in the legal research field, with Westlaw being the other. Now, Westlaw, of course, has its own competing project called West Trial Notebook. Many of the principles that we're going to talk about with regard to CaseMap no doubt are just as applicable to West Trial Notebook. So even though we're not going to talk about that product, much of what you learn by way of workflows, the way of thinking about organizing a case, is going to be equally applicable to that software. And no doubt there are other software packages out there that are comparable. Having said that, though, CaseMap is without a doubt the leader in this field. It is a software package that's been adopted by U.S. attorneys' offices across the country in the Department of Justice. It's used regularly by federal public defenders, as well as by large firms engaging in commercial and complex litigation. To me, I think it's indispensable. I couldn't imagine handling a case with more than just a handful of documents or a handful of people without using LexisNexis CaseMap. So that's the topic of this discussion. And what is CaseMap? Well, of course, the best way to understand what CaseMap is and the way it works is to go to LexisNexis and download it. You can download a 30-day free trial version. And as with any software, the only way to learn how to use this program is to play with the program, is to download it. There is a case that comes with it. It's called the Hawkins case that has, it's an employment case that gives you some facts, some people, some documents to work with so you can understand the functionality. So I commend that to you, that you go to the LexisNexis site and that you download it and that you start to essentially teach yourself how to use it. What I hope to do in this video is to give you a broad overview of CaseMap so you can understand at a high level what it can do and what aspects of your case it can help you organize. In subsequent lectures, we'll talk about more specific functionality, more particularly dealing with documents, and then using CaseMap to write briefs, to prepare for arguments, and to prepare court-ordered pretrial orders, court-ordered witness lists, exhibit lists, and those sorts of things. But for now, we're going to talk about CaseMap at a very high level. Well, at a high level, CaseMap is a table-based method of organizing data. And by table-based, I mean it looks like this. This is a very, very familiar format. It's one that we've all dealt with if we've dealt with Excel, if we've dealt with just simple tables with rows and columns in Word or WordPerfect. And this is the very basic layout across all of CaseMap's different tables, whether we're talking about the fact table, the persons table, the documents table, they all look basically the same. So it is, at its heart, fundamentally a table-based method of organization. Well, as a table-based method of organization, it has rows and it has columns. Each row is sometimes called a record. This is one bit of information, but along that axis, there may be other related bits of sub-information that are stored in the columns. So for example, on this table, you can see the date and time, the date and time column that has various different dates and whatnot in it. And we've got the fact text column here, which again has the facts that are you would type in that are relevant. They have sources and various other types of column information that we'll talk about in more detail. One thing to keep in mind is that these tables are highly customizable. Generally, you'll only have 2 or 3 different columns in play at any given time, but you can show and hide the columns as you wish, and then add new columns that of different types that allow you to be very highly custom in your approach to using CaseMap. But for now, just understand that it's a table-based method of organization. The highest level, and really the queen table, the table served by all of the other tables, is the fact table. And that's the table that we just looked at. The fact table typically is going to have a date and a time, a description of what happened on that date or time, because all facts happen at a date or a time, and the source of that fact. The worker tables are all of the rest of the tables that service the fact table. And these are the document table, the persons table, the issues table, and finally the questions table. Now, we'll deal with each of those in turn, but first let's talk about the fact table, the queen of all of these tables, because it really shows you what CaseMap is all about. Well, before talking about what CaseMap is all about, let's talk about what cases are all about. And I still remember when this epiphany hit me back in the late 90s. I had been to law school for 3 years in the late 80s. I had worked as an associate at 2 very large law firms, one in New York City, one in New Orleans, and had worked on dozens, if not hundreds, of cases. But when I first sat down to use CaseMap to help me organize a case, it suddenly struck me at that time, maybe at that late point in my 10 years into being a lawyer perhaps, that cases really are built up of facts. Facts are the atoms of cases. What do I mean by that? Well, an atom, of course, is the, I guess, Greek term for the smallest divisible unit of matter. The fact, an individual fact, is the smallest individual unit of a case. Now, of course, a case is made up of hundreds of facts. Take a simple red light, green light case. If you're representing the plaintiff and it's your contention that I, the defendant, ran a red light at the intersection of Main Street and South Boulevard on January 1st of this year. Well, there are a lot of facts involved in this case. It's a simple red light, green light case, but there are facts like, for example, my speed is a fact, the lighting is a fact, the road conditions, another fact, the weather conditions, another fact, the color of the light, another fact. Critical fact, but a single fact nonetheless. The state of impairment of the drivers, where the drivers were before the accident, what cars they were driving, the speeds of those automobiles, whether the brakes were functional on those automobiles. I could go on, but the simple point is this. Every case is built up of fact upon fact upon fact. What CaseMap helps you to do, and more particularly, the fact table of CaseMap helps you do, is to organize all of these facts in one place, to categorize them, to assess them, to source them, and in that regard, CaseMap is the fact table is really the central table around which all of the other tables rotate. All right. Take our red light, green light case, and let's just take one fact, which was the light was red facing down Main Street at the time of the accident. Well, that's a fact. How do we get that fact? Well, we've got to go out. Remember, facts don't come to us. They don't just wind up in our law offices and sit next to us in the client chair. We have to go out there and get them. Well, how do we get facts? Well, we get them through researching them on our own, maybe on the internet, maybe by going out and looking things up in books or in other documents. We might gather them by leaving our offices and going out into the field and taking pictures of skid marks. We may discover them through, and I kind of distinguish gathering from discovering, in the sense that gathering is the informal fact gathering process, while discovering facts is the way that you get facts through the formal discovery process. Once we get those facts, a big heap, a pile of facts doesn't really do us much good. We have to take them and we have to organize them and arrange them in a way that makes them, first of all, readily usable, and that makes them understandable. We cannot understand facts unless they are placed into a context related to issues and cases and related to one another. We typically organize information hierarchically, and then we arrange that information as well. So fact gathering, discovering, researching is not enough. We have to take them, we have to organize them, we have to arrange them. And then ultimately, we have to present those facts to a fact finder, perhaps at trial if the case goes to trial, perhaps to our opponents or a mediator in an effort to try to settle the case. And we have to use the facts in a way that's persuasive, that tells a story, that it is appealing to logic and emotion. Those are that last step, that kind of telling the story, is really the province of trial advocacy and rhetoric and courses in public speaking and persuasion. But you have to have something to say. You have to have structure to your story. And that takes us back to the information, the organizing and arranging facts. What CaseMap does at its best is help you with organizing and arranging the facts. That's where CaseMap is not going to go out and research and gather the facts for you or discover them. It's not going to tell the story for you. That's where you as the lawyer and your investigators come in. Where CaseMap is indispensable, in my view, not just helpful, but indispensable, is in organizing and arranging those facts in a way that makes you able to tell the story that you need to tell. So, how does it do that? Well, back to the fact table. If our red light, green light case is a case that is built up simply of just facts, those atoms, what do you do? Well, of course, you're going to go out, you're going to collect, and you're going to organize facts. Light was red facing down Main Street, according to an eyewitness, Jane Smith. The roads were slick because the rain had just started to fall. The defendant's car, my car in our hypothetical, was going at what appeared to be 40 to 50 miles an hour when the posted speed limit was 30. Again, these are facts that you're collecting from interviewing witnesses, perhaps from getting interrogatory answers, from taking statements, from taking depositions. Now, once you are out there gathering the facts, you are going to put the fact on your fact table. Now, all facts should have a date and a time. If Jane Smith saw the car accident, she saw it happen at a certain date, on a certain date, and at a certain time. If I was drinking before the accident, I was doing so at a bar nearby the scene of the accident. I was doing that on a certain date, on a certain time. Obviously, it's important to prove that I was drinking before the accident, not after the accident. So you need to, when you put in the table that I was drinking as the defendant, you need to put the time I was drinking, right? So all facts should have a date. Now, it may be that you don't know what the date of a fact is at a certain point in your collecting an organization process. Take this, for example. Suppose that some witness whom you interview tells you that I, the defendant, have been involved in 5 wrecks in the past. Well, that shows that I'm not a very careful driver, but you don't know when those wrecks, you don't even know if those wrecks happened, but you certainly don't know when they happened. But you might on the fact table put defendant Cialino involved in 5 wrecks. And all it would, the only fact you know is that it's before the day of the accident in question. Well, it doesn't have a date yet, it's uncertain, or the date's fuzzy. CaseMap can handle that. It can handle a fuzzy date. It can handle no date. Ideally, you know the exact, not just date, but also time of all of your relevant events, but they all should have a date. Facts must have a source. The Saints won the Super Bowl a few years back. That's a fact, but what's the source of it? Well, you just kind of know it. But if you had to prove it, how would you prove it? Because as lawyers, facts standing alone are interesting and important, but they're useless to us unless we can prove them. And we typically prove facts through a witness or through a document. Back to our car wreck case. Suppose you have a hunch that I was drinking before the accident. And what if, in fact, I was drinking? How are you going to prove it? That fact needs to be sourced to a source of proof. It may be that you have interviewed a bartender, and the bartender tells you that he served me 6 gin and tonics within 15 minutes before the accident. Well, the source of that fact is the bartender, and you'll need to know his name and his contact information so you can serve him with a subpoena at some point in the future. So facts must have a source. Suppose the traffic light was stuck on green in one direction and red on in the other direction, and that fact is of significance to your case. Obviously, it would be. That might be sourced to a Department of Transportation document. If you want to prove that the light was broken, you would prove it using a public record. That's the source of that document. So by saying facts must have a source, the source is usually a person, but often a person and a document, because people can make statements to you and then to documents. So facts must be sourced almost always to a person and usually also to a document. Finally, facts must relate to an issue. Back to the Saints. Told you the Saints won the Super Bowl a few years back. You know it, I know it, and if I had to prove it, I might call Sean Payton to testify that he was there and he personally saw it happen. But what does that have to do with our red light, green light case? Not a damn thing. It's a fact, but it's not one that relates to an issue. If a fact winds up on our fact table, it better be relevant to the case. It better be linked to an issue. So facts must relate to an issue. It may be, for example, a fact like the plaintiff had a broken neck as a result of the accident. Well, that's a fact, all right. It's got to be sourced to a doctor, perhaps, and an x-ray, perhaps. But it needs to relate to an issue. Does it? Well, it does. This is a personal injury case. And the two big issues in all personal injury cases are liability, damages. That fact relates to damages. That fact is relevant to damages. You should tag it as relevant to damages. Whether the light was red, facing down Main Street, whether I was drinking, those all go to liability, but they go to sub-issues within liability. Facts have got to relate to an issue. Why? Well, for a couple of reasons. First of all, to justify being on your fact table in the first place. And second, because there will be times where you want to see what facts do I have that relate to damages? What facts do I have that relate to the light color? And you want to just cull out, for purposes of your analysis, those facts. If they're tagged to the issue, to an issue, you can easily do that. And we'll talk about how to do that through filtering and sorting later. But when you are constructing the fact table, make sure that every fact relates to an issue. Okay, how do you organize facts? So suppose that on our red light, green light case, you have sent out some discovery requests and you have gotten back medical records, you have gotten back police reports, reports from the Department of Transportation regarding the functionality of the lights. You've downloaded weather information for the day to show lighting, rain, whatnot. What I call this is mining. When you get the documents in the case, you mine them for information. And this is the goal. The goal is as you read a document, you are going to take from the document bits of gold and silver and bronze. You are taking the good stuff out of the document and putting it in CaseMap. The goal is every time you have a document in front of you, you are going to pull out all of the stuff that's worthwhile. And by worthwhile, I mean that's very helpful or that's very harmful, because you have to know about that as well. And you will never look at the document again. Now, we know you're going to look at the document again, but the thinking, the mindset you have when you are reading documents is that once you look at the document and you mine it, there's no need ever to go back to it again, because you've already gotten all of the gold, silver, and bronze from it. So as you're organizing the facts, you're getting the facts from places, and you're generally getting them from documents and also from witness interviews that are often memorialized in documents. And you're pulling those facts out and you're putting them on the fact table. And again, you mine them from documents and you mine them from witnesses. Now, just as a matter of best practice, it's best really anytime you interview a witness to take all of the facts from the witness and put them in a document. That way, when you are relying upon or taking facts from that witness and putting them into CaseMap, you have them sourced to not only a witness, but also a document, namely your memorandum of the witness interview, if it's just your memorandum, or perhaps a signed statement from that witness in which the witness has adopted that writing as containing the facts that they have personal knowledge about. So you will do the mining process and put those facts in CaseMap. Once the documents are in CaseMap, and while you're putting them in there, you're going to tag them. By tag them, I mean you are going to identify the source of each one of those facts that you have mined, and any documents that are related to that or which are directly the direct source for that fact are going to be tagged. You also want to tag the people that are related to that fact, that are either by way of sources or mentioned in the fact. So for example, suppose that a witness, Jane Smith, was walking down Main Street and she saw the accident. She saw that the defendant's car was speeding. She also saw another witness, Jones, who saw the accident. Well, notice that I mentioned a couple of different names. I'm going to source the fact that the defendant was speeding to her, but I'll also mention that she saw Joan Jones, another witness on the scene. So I have tagged the fact that she has given me both to the source, her, and also I've mentioned the related person. Now you'll see later that when it comes time to filtering out, if you're, for example, getting ready for a deposition of Joan Jones or Jane Smith, or getting ready to do a witness outline, you're going to want to see all of the facts that just relate to those witnesses, in which those witnesses are tagged or for which they are the source. If you tag them as you go, it'll be easier later on to filter out and see just those facts. Finally, you're going to want to tag the facts to the related issues. As I've already said, if you're going to put in your fact table that there was a broken neck suffered by the plaintiff, you're going to want to tag that to liability and sub-issues under liability. Why? So you can, again, filter out and see what facts you have on that. Okay, well, that's the persons table. Again, just a broad general overview. That is the queen bee of all the tables. Let's start talking about some of the worker tables. All right, first of all, the persons tables. Now, I hate to sound so callous about human beings, but as far as cases go, people are merely sources for facts. They are not an end in themselves. They are a means of getting and proving facts. You don't care about Jane Smith. You care that she is a witness that saw the defendant speeding, so she serves that end in your case. She is a source for that fact. She, keeping that in mind, her name needs to be on the persons table because she is a person with a fact relevant to the case. So how do you organize her and other like people with some connection to a case? Well, first of all, you're going to put her name on the table, but then you're also going to have a column that you're going to populate with this information. That is the person's role in the case. People all have some role in the case. They're the defense lawyer, the judge. In our case, Jane Smith happens to be an eyewitness to the speed of the defendant's vehicle. Why do you put that on the persons table? Well, you do it because when you look at the persons table, you want to, and you scan the names of the people involved in the case, you immediately want to remember why Jane Smith is on your table. And she's on there because she is an eyewitness who observed the speed of the defendant's car. So I would put in that role in the case column that she is an eyewitness who saw the speed of the defendant's vehicle. Now, I say people should have a, quote, role in the case. They really must have a role in the case. This is the column that justifies their inclusion on the table. If you just threw on a random name, Joe Smith, and you didn't put his role in the case, you'd be wondering, why the hell did I put him on the table? Well, if he happens to be a lawn maintenance man who saw the defendant's car speed, then you'll know when you look at the table why he's on there. People should have contact information. Why? And by contact information, I mean a service address, a physical address. I mean a mailing address, an email address, and telephone numbers. Why? Because you're going to want to track these people down later, to call them, to tell them when the trial is, to talk to them again, to follow up, to serve them with subpoenas for documents and for testimony. You got to have the contact information for all people, and you record that information on the persons table. Next table, the issues table. Now, as I've already said, facts belong on your fact table only if they relate to an issue. The issues place facts in contexts. Take, for example, in our case, negligence is an issue in our red light, green light case. You can prove negligence through violations of statutes, through behavior that is inconsistent with the behavior that would be exhibited by a reasonable man under like circumstances. So for negligence, there are a lot of facts that show negligence. Speeding, failing to yield the right of way. Perhaps the fact that it was raining suggests that the defendant's speed should have been lower, perhaps even than the speed limit. The speed limit is something that's important to show what the standard of care was. And again, that is got to be tagged to the speed limit on the street if it's just 25 miles an hour. And the fact for that row might just say the speed limit on Main Street is 25 miles per hour. What would it be tagged to? Negligence, speed. Now, you're going to have other facts tagged to negligence, speed, right? Like the fact that the defendant was speeding, as said by John Smith, as said by Jane Doe. those would just be 3 facts on your fact table, right? All tagged to the same issue: negligence, sub-issue, speed. So issues place facts in context, and issues justify the inclusion of facts on the fact table. How do you organize issues? Well, as we've already said, issues must be organized hierarchically, and by hierarchical organization, we've talked about this before with mind mapping, but I mean having a high level followed by lower levels, and then sometimes even by lower levels of information. Why? Well, we remember things best when we organize them hierarchically. Also, we can see logically why facts find themselves on the fact table. So it's important to organize them hierarchically, and thankfully, CaseMap allows for hierarchical organization. So by hierarchical organization, in our red light, green light case, you would have the 2 perhaps big categories, main categories being liability and damages. Under liability, you might have speed, you might have weather, you might have other subcategories, sub-issues. Damages, you're going to have general damages like pain and suffering, loss of love and affection, and then special damages, medical expenses, lost wages, future medicals. All of those need separate sub-tabs in that hierarchical organization of issues. Again, just so you can logically organize your case, but also so you can filter out issues as you go. Issues should, but not necessarily must, cite to the relevant law. And again, on a negligence case, you don't need to be citing Louisiana Civil Code 2315 every time you write negligence. But there are times where issues are peculiarly relevant in a case because of some special statute or case. So if that's the case, you want to tag, you want to cite to the relevant law. Like, for example, I do a lot of disciplinary cases. And in disciplinary cases, the appropriate sanction is always a key issue. What the appropriate sanction is determined by the ABA standards for imposing lawyer sanctions. And it depends on the lawyer's state of mind, the harm occasioned by the lawyer's conduct, those sorts of issues. And I always cite to those, and also mitigating and aggravating factors. I routinely cite provisions of the ABA standards when I'm organizing my facts for a disciplinary hearing. The questions table. This is really just kind of a catch-all to-do list, a case-specific to-do list, where you're simply tracking facts, documents, issues, and people that need finding an organization. So it may be, for example, that you've heard that there was a witness named Jane, last name unknown, who talked to the defendant right after the accident. You might just put that on the questions table. Find Jane, last name unknown. And just as a placeholder to remember that she was out there and she needs to be found. If you need to get the plaintiff's medical records from the emergency room, you've gotten them from other treating physicians, but not the ER, you might go to the questions table and say, need ER records for plaintiff. Again, it just keeps track of what needs to be done. Now, these should be assigned. There are some questions that you're going to assign to your client, to your investigator, to your associate, and to yourself. Responsibility for answering the question is important because then you can see what you need to do and what others need to do. I always keep track of these, and if I ask a client to get me some information, and that's usually the case, I can always open up at the next meeting the questions table and say, look, client, I've asked you to get A, B, and C. What have you gotten? And again, it holds people accountable. It makes sure that facts don't fall between, or excuse me, issues that need to be done, to-dos, don't fall between the cracks. And responsibility really is key. They also should be prioritized. Some things you need to get a lot more quickly than others. So it's just a good practice to give them a high, low, medium type priority. Not critically important, but it's just good practice. Okay, the last table that we'll talk about in our general overview here is the document table. Now, again, this is just our general overview. We're going to spend more time talking about documents and organizing documents, manipulating, Bates numbering documents, etc., in an upcoming lecture. But at a high level, keep in mind that documents, just like people and issues, are not ends in themselves. They are merely sources for facts. Now, I hate to treat documents just as a means, just as something to help you with your case, but they are nothing more than that. They're merely sources for facts. Well, but they are going to be on the document table. Every time you get a document that relates to your case, you're going to put it on the document table. And how are you going to do this? Well, first of all, they've got to have a descriptive name. You have to be able to look at the document table and see what the document is. It can't just be a document that's called 00435 Smith. Well, or Exhibit 7. What does that tell you about the document? Nothing. You got to be able to look at the table and read the name of the document and understand what it is. Now, if you followed the protocol for naming documents that we previously discussed, namely date by year, month, day, author, and an extended description of what the document is, like, for example, 2013-06-29 Cialino letter to Smith regarding medical expenses. Well, that is a long descriptive file name that when you look down at the document table, you will know immediately what that document is. It doesn't just say Smith 2346. So documents must have a descriptive file name for a number of reasons. Number one, you want to look at the table and know what the document is. Number two, when we talk in our next lecture about preparing exhibit lists and pretrial orders using CaseMap, you just want to be able to produce and attach to whatever it is you're doing as an index the document table, at least a filtered version of the document table. And you're not going to be able to do that if your descriptive name of the file of the document is garbage. So make sure that your documents have descriptive file names. Documents should have a date. Why? Because when you go look for a document, you want to do it chronologically. You also want to be able to do essentially a chronology of the case with documents. You're going to do it with facts mostly, but sometimes you want to do it with documents. As we said when we talked about document naming conventions, the names of all of your electronic documents should have a date. Very easy to do. If you've done that in naming the documents, when you bring those documents into CaseMap, they're going to already have a date. But sometimes you'll get scribbled handwritten notes that have no date. Sometimes somebody has forgotten to put a date on a document. Can CaseMap handle that? Yes. CaseMap, as we've already said, can handle unknown dates, fuzzy dates, and by a fuzzy date, for example, we know it's like from August of 2008. Well, we don't know the date, the particular day. Then CaseMap can handle that. But that's better than no date at all. So documents should have a date. We understand that some documents won't, but virtually all of them should. And it should be readily determinable from the name of the document if you've properly named your electronic files. Documents should have a Bates number. What is Bates numbering and why should documents have them? More on that in an upcoming lecture. All right, well, this is what the document table looks like. And more on this when we start talking about manipulating documents and organizing documents using CaseMap and using Adobe Acrobat. But what I almost always use on my document table is, again, a date for the document. I almost always Bates number my documents, which gives me a Bates range, a Bates beginning, and then a Bates end. Right now, once you do that, then CaseMap will automatically figure out how many pages are in the document, which is just kind of useful to have on your index. Cases also will have a short name. Usually that's going to be the same as, the same as the Bates beginning number, and it is here. Again, you want to have as few confusing bits of information per document as possible. So I think it's a good policy just to use as the document's ID number or short name, the Bates beginning number. Then, here's the pages. This is automatically generated by CaseMap from the number of the Bates ending and Bates beginning range. And then finally, here is the descriptive name. That's the one that's so important that you can just look at and immediately tell what it is. Now, I think you need more detail than this, like Lang memo to Reagan. It should say Lang memo to Reagan, Ray, employment termination of Hawkins. Again, more information like this one. Varvo tip letter. Shouldn't just say Varvo tip letter. It should say Varvo letter to Smith regarding tip on employment issues. Source of document is not a mandatory field, but it's one that I think is useful to track, because you often want to know, did I get this from my opponent? Did my client give this to me? Did I find this on my own? Good to track documents by sources. And then finally, since you're going to be handling documents electronically, very good to have almost all of your documents linked to a PDF. The good thing about linking a document is this is the name of the file here, but even better is this little paper clip over here. The paper clip allows you to double click on that paper clip and open up in Acrobat the document so you can see what the document actually is. Again, very powerful combination, digital document storage, Acrobat, and LexisNexis CaseMap. Makes handling cases large and small very manageable. Once you've done the hard work, and it's hard work, getting the facts, documents, people, and issues in the case, you've gone a long way to organizing it. Okay, well, that is the overall high-level overview of what CaseMap can do. In future lectures, we are going to talk more specifically about managing documents using Acrobat and CaseMap, and also talking about preparing for witness outlines, arguments, for court-ordered exhibit lists and pretrial orders, all which, nothing's effortless in the practice of law, but all is much easier and more readily facilitated if you've done the front-end spade work of putting your information and doing a good job of comprehensively mining your documents and putting all of information in the fact table and in the attendant worker tables.